a jury of your peers have found you guilty of killing 9 people.
For somebody to be that callous and cold, to go to a visual and open on a crowd of men, women, and children.
Okay, that's what you would expect an officer to do. He doesn't shoot. He's not chasing him, doesn't shoot him in the back. What Olsen does is he says, stop!
Tyrese Turner, a Columbus boy with a lengthy history of juvenile offenses, was indicted on multiple counts of aggravated murder and murder following a deadly shooting at Crum Park on June 3, 2024. The incident occurred during a vigil for 18-year-old Damaya Cummerlander, who had been fatally shot the day before. Turner, then 18, allegedly opened into the crowd, killing Jaquan Kimbrough and Lonnie Johnston. Authorities suggest a possible motive connected to a past family feud. Cummerlander was reportedly the niece of a man imprisoned for the death of Turner's mother. Columbus police arrested Turner and 31-year-old Ladavia Fortner in connection with the shooting. Turner was indicted on 2 counts of aggravated murder, 4 counts of murder, and 6 other felonies, including tampering with evidence and having weapons under disability. Fortner was also charged with murder. Turner's past included over 40 juvenile charges and dangerous incidents such as high-speed chases and assaulting a police officer. Following his arrest, prosecutors asked the judge to deny bail for Turner, citing public safety concerns.
And we look at his history, Judge. With respect, I just don't see any type of condition this court could impose upon somebody with his record and the conduct he's done here that would assure us the safety of the community.
But I would ask the court to consider setting a bond, whether it be a high bond in deference to the charges and his history and the necessity of protecting society. I certainly understand that, but to hold somebody without bond completely, we believe is too extreme in this case.
The victims' families also pleaded for him to remain in custody, describing the act as cold and deliberate.
He is right where he needs to be. For somebody to be that callous and cold, to go to a visual and open on a crowd of men, women, and children should not be free.
Turner was denied bail and ordered to remain in custody until his trial, scheduled for August 2025. Co-defendant Fortner later pleaded guilty to involuntary manslaughter. Her sentencing is set for October. In March 2015, Robert Olsen, a former DeKalb County police officer, responded to a 911 call about a naked, unarmed man, Anthony Hill, who was behaving erratically outside an apartment complex near Chamblee, Georgia. Hill, a 26-year-old U.S. Air Force veteran with bipolar disorder and PTSD, reportedly had a bad reaction to his medication. Olsen shot Hill within seconds of arriving on the scene, resulting in Hill's death.
Pulled out a weapon to stop Hill. He did not pull out his weapon to kill. What Olsen does is he says, stop! Okay, that's what you would expect an officer to do. He doesn't shoot. He's not chasing Hill, doesn't shoot him in the back.
Despite Hill being unarmed, Olsen claimed he acted in self-defense, fearing for his life.
Do you have options now of what you want to do if I'm coming at you from here?
Yes.
Okay, could you use your OC spray, get it ready and mace my face?
Yes.
Could you bash me with your aspeton?
Yes.
And we can belittle Officer Olsen and say you had all these other avenues, but he did what he thought he had to do for self-preservation at that point, and it was reasonable.
I mean, there's video that totally contradicts what he's saying. He's saying that Anthony beat him up. He's saying his hands are here, and the eyewitnesses are saying Anthony's hands were back here.
Prosecutors argue Olsen failed to assess the situation properly, violating department policy and using deadly force unnecessarily. In 2016, Olsen was indicted on charges including felony murder, aggravated assault, and violating his oath of office. His trial in 2019 resulted in a conviction for aggravated assault and oath violations, though he was acquitted of felony murder. He was sentenced to 12 years in prison, but in March 2024, the Georgia Court of Appeals overturned his convictions, ruling that critical evidence had been improperly introduced during the trial. Olsen was granted bond with conditions and is awaiting further court decisions. In November 2024, Junior Thomas Babcock, 42, was arrested in Chatham County, Georgia, after being charged with the murders of his parents, Connie and Daniel Babcock, and his son, LJ Babcock. Authorities responded to the scene on Quaco Trail, where they found the victims dead from shot wounds. Evidence collected at the scene included shell casings, bullet holes, and signs of a violent struggle.
I have yet to get the autopsy report, but I did attend the autopsy, and there were fragments of shot from a shot.
Detective Kiana Robbins later testified in court that Babcock had confessed to the killings, explaining that he believed his family members were the beast and the devil, and that he needed to eliminate them for the good of the world.
He advised that he was the Shiva and that Daniel was the beast. Daniel was the devil. Miss Connie was the devil's wife, and Junior was the beast, and that he needed to get rid of them for the good of the...
Does that indicate any kind of sign of mental illness to you? I know you're not a doctor, but you are an officer.
In January 2025, a grand jury indicted Babcock on multiple charges, including malice murder, felony murder, aggravated assault, and possession of a firearm during the commission of a felony. The case, which has drawn significant attention, is now set to proceed to Superior Court after the judge determined there was enough evidence to move forward with the charges. In November 2019, Jeremiah Seaton shot and killed his girlfriend, LaMaya Mitchell, at the intersection of Seminole and Atwood Streets in Savannah, Georgia. Seaton initially claimed the shooting was an accident, but investigators found inconsistencies in his statements. Mitchell's mother, April Jones, described the harrowing experience of discovering her daughter's lifeless body, a moment that forever altered her life. More than 3 years later, Seaton was convicted in August 2023 during a bench trial, where Judge Timothy Wamsley presided. He was found guilty of felony murder, aggravated assault, and possession of a firearm during the commission of a felony, but was acquitted of malice murder. At the sentencing hearing in December 2023, Seaton was sentenced to life in prison with the possibility of parole.
I just want everybody to remember my baby, don't forget my baby, because at the end of the day, they can still visit him. I can't visit mine. I go to a graveyard to visit mine. And this is a mother's worst nightmare, a parent's worst nightmare. Yeah, 2 families are devastated because he threw his life away by taking mine away. He took a part of me when he took my child. Something I'll never get back. My family dynamic, my mindset will never be the same.
April Jones, wearing a shirt with LaMaya's pictures and the words, "The heavens always win," and "vindication and justice," expressed her heartbreak, emphasizing that while Seaton could still receive visits, she could only visit her daughter at a graveyard. Judge Wamsley described the case as a tragic loss of 2 young lives, one through Seaton's actions and the other through LaMaya's death. On January 21st, 2013, Rebecca Foley, a 21-year-old student at Savannah State University, was tragically murdered outside her apartment during an attempted robbery by a gang.
She had a red bug and she drove it everywhere, and unfortunately, that was the target that night.
The gang members involved were identified as Roderick Parrish, Jordan Campbell, and Kevin Smith. Parrish and Campbell were convicted in 2018 and sentenced to life without parole for their roles in the murder. However, Smith's case faced repeated delays due to a hung jury, with the trial being rescheduled several times.
Kevin Leonard Smith's team is asking for a private investigator and for the state to pay for it. And so the judge granted that. And that's what we're waiting on.
In January 2023, Rebecca's family marked the 10th anniversary of her death. During this time, they reflected on her adventurous spirit and honored her memory.
1 year we went to SeaWorld. 1 year we got tattoos. 1 year, each time it's different. This year, we went to Tybee and just had a quieter reflection because that was one of Rebecca's favorite places. The holidays are terribly hard. In fact, I avoid them. I don't do Christmas or Thanksgiving because she was there and she's not.
Alongside the criminal case, Rebecca's family pursued a wrongful death lawsuit against the apartment complex owners, claiming they were aware of safety issues but failed to take action. The lawsuit was ultimately settled for an undisclosed amount.
It's bittersweet. I'd rather have her. And that's the truth. It would be better to just have her.
Finally, in August 2024, Smith was convicted of felony murder and aggravated assault, receiving a life sentence without parole. While the family has found some closure through the criminal conviction and the settlement, Rebecca's mother expressed that the loss of her daughter could never truly be replaced. December 2018, the remains of siblings Mary and Elwin Crocker Jr. were discovered buried in the backyard of their father, Elwin Crocker Sr.'s Guyton, Georgia. The siblings had been missing for years, with Mary disappearing in October 2018 and Elwin Jr. in November 2016. This led to the arrest of 5 individuals, including their father, stepmother Candace Crocker, step-grandmother Kimberly Wright, Wright's son Mark Anthony Wright, and Roy Prater. In March 2019, they were indicted on various charges, including malice murder and cruelty to children. Candace Crocker and Roy Prater later pleaded guilty, with Candace receiving a life sentence and agreeing to testify against the others. By December 2023, the case remained in pretrial proceedings with over 60 motions filed. The defense for Elwin Crocker Sr., Kimberly Wright, and Mark Anthony Wright requested the dismissal of the grand jury's indictment, citing issues with the jury's composition.
In terms of creating a constitutional grand jury, and that is randomness and inclusiveness. There was some serious compromise of those 2 goals.
Is that person had a higher chance of being selected in that group of people who were some.
However, the motion was denied. No trial date has been set, and no sentencing has occurred for those who pleaded guilty. The case continues to move through the legal process as the remaining defendants prepare for trial. On July 4th, 2021, 3 people, Brittany Sneed Mack, Travis Sneed, and Christina Souls, were tragically murdered in a mobile home in Bullock County, Georgia. The victims' 3 sons were present during the killings, but were unharmed and later found crying at a neighbor's door. Evidence pointed to Rolando Milan as the culprit, with matching Travis Sneed's found on Milan's shoe, and a prior argument over money between Milan and Sneed. Milan was arrested and charged with malice murder, felony murder, aggravated assault, and cruelty to children. Milan's trial took place in November 2023, where the prosecution presented compelling evidence, while the defense argued insufficient proof. The jury deliberated briefly before finding Milan guilty on all counts. During sentencing, Milan continued to deny his involvement and pointed out the lack of evidence.
Of life without possibility of parole. Do you understand the sentence of the court?
I know, but for what?
For what you've been convicted of.
All I'm just saying is, like, she said it was blood on the bottom of my left shoe, eyes on the side.
Jury has spoken.
He was sentenced to life in prison without the possibility of parole, plus an additional 5 years for firearm possession during the crime. The verdict was followed by emotional statements from the victim's family, including Brittany Sneed Mack's mother, who expressed both forgiveness and a demand for justice. On September 11, 2018, Antonio May, a 32-year-old man, was arrested for misdemeanor trespassing after allegedly throwing rocks at the American Cancer Society building in Atlanta. After being diagnosed with a substance abuse psychotic disorder at Grady Memorial Hospital, he was cleared for transport to Fulton County Jail. However, instead of being placed in a medical observation unit, he was put in a general holding cell. When May exhibited behavior that concerned jail staff, 6 deputies, Aaron Cook, Guido Dela Cruz, Omar Jackson, Jason Roach, Kenesia Struder, and William Whitaker entered the cell. They used a taser and other physical measures to subdue him. Tragically, May became unresponsive and was later pronounced dead. In November 2021, a grand jury indicted the deputies on charges of felony murder, aggravated assault, and violation of oath of office. However, in 2022, the judge dismissed the indictments, ruling there were procedural issues regarding the deputies' legal status. In October 2023, the Georgia Supreme Court overturned this decision, stating that the deputies did not qualify for special protections under the law.
We are pleading not guilty.
In a 2024 court hearing, 6 deputies pleaded not guilty to charges in the death of Antonio May.
We believe that he's innocent, and we will fight these charges.
Guito de la Cruz's attorney highlighted the emotional distress expressed by his client over the case, initially believing he wouldn't face charges under the prior district attorney's leadership.
Because at one point, he believed that the district attorney's office was not going to charge him based on a representation from the previous regime. The new regime made a different decision, and so it's been an emotional roller coaster.
As the case moved forward, Judge Paige Reese Whitaker recused herself due to potential conflicts of interest.
Because these are all Fulton County deputies, and the deputies are the ones that protect the courtrooms and protect the courthouse and transport people from the jail. So I understand the potential conflict there, because there are people that she's dealt with, there are supervisors that she is fond of, people that she's had relationships with in her career in Fulton County.
The trial was reassigned to Judge Robert McBurney. Throughout the legal process, Fulton County District Attorney Fonnie Willis remained determined to pursue justice for Antonio May and his family. On February 2, 2018, 33-year-old Anthony Lingos was struck by a vehicle while walking near the intersection of East College Avenue and Candler Road in Decatur, Georgia. Lingos was leaving the Trackside Tavern when the accident occurred. He was transported to the hospital, but was later pronounced dead from his injuries. For months, authorities worked on the case, following up on leads and tips from the community. After an extensive investigation, Decatur police arrested 39-year-old Omari Young on October 1st, 2018, charging him with vehicular homicide and hit and run. Police allege that Young was the driver who struck Lingos and fled the scene without offering any help. His first court appearance was on October 3rd, where a judge granted him a $10,000 bond.
Yeah, it's good to know that somebody will be held accountable for that. It's also hard, too, I think, a little bit about that person's family, and now they're going to have to go through what I'm sure is a nightmare for them.
Lingo's family, while relieved that an arrest had been made, expressed mixed emotions. His brother, Andrew Lingos, shared that while they were grateful for the progress, the news brought back painful memories.
Definitely stirred up all the feelings again. I kind of felt like I was back in February. So it's been really tough. At the same time, you know, I'm glad that they found somebody, but you know, it still doesn't bring Tony back. People make choices, and that's what life is about. You can make good choices or bad choices. And that night, that man decided to make a bad choice, and it cost my brother his life. And you know, we're just trying to move on from that. And he's going to have to pay for what he did.
The arrest marked a significant step forward in the case, but the family continued to grieve the loss of their loved one. As of now, the legal proceedings are ongoing, with no further updates regarding Young's trial or legal status. In September 2019, Eric Keyes was riding his bicycle in Cedartown, Georgia, when he was struck by a car driven by Ryan Dover. Instead of stopping or calling 911, Dover contacted his friend, State Representative Trey Kelly. Rather than seeking help, Kelly joined Dover at the scene, where they discovered a bicycle in a ditch but saw no sign of Keyes. Still, neither man alerted emergency services. About 40 minutes later, Cedartown's police chief was informed, but even he did not immediately call 911, only dispatching an officer. Keyes was eventually found alive, but critically injured. He later died at the hospital. Medical experts believed he might have survived had he received timely care. Keyes' brother pointed out Dover's negligence.
Alive, unconsciously internally needing help from us, and nobody was there. You don't just go and look. You dial 911 first. None of them did that.
Following public outrage and a long investigation, a grand jury indicted Dover on charges of felony hit and run and reckless conduct. During the 2023 trial, Dover admitted he left the scene without notifying authorities.
Despite the fact that you told the police that you know what to do after an accident, instead of calling the police, you called Trey.
Yes, sir. He's the one that I lean on.
Okay. In fact, I think your words were, you knew that Trey could help you.
Yes.
Yeah, the court can look at the law on this thing, apply it, understanding that the facts are what they are, and that Mr. Dover is the person who's on trial, not someone else with better coping, with better understanding. And I think that the court at the end of that should come back with not guilty on both counts.
His defense argued mental challenges impaired his judgment, but the court ultimately found him guilty.
So I find that Mr. Dover, for the reasons that I have expressed, is guilty beyond a reasonable doubt as to count 1 hit and run and count 2 reckless conduct.
In August 2023, he was sentenced to 5 years in prison, the maximum allowed under Georgia law for the felony charge. State Representative Kelly was indicted for reckless conduct but was cleared of charges in December 2021, as the court ruled he had no legal duty to act. In the aftermath, Keyes' father filed a federal wrongful death and civil rights lawsuit against Dover, Kelly, Police Chief Jamie Newsom, and the city of Cedartown, claiming their delays and inaction contributed to Eric's death. On August 22, 2022, a tragic shooting spree unfolded in Midtown Atlanta. Risa King, a 34-year-old woman, allegedly targeted individuals at 2 separate locations. The first shooting occurred at 1280 West Peachtree Street, where King fatally shot Michael Shinners, the building manager, and injured Mike Horn, the chief engineer. Shortly after, King went to 1100 Peachtree Street, where she killed Wesley Freeman, a former colleague. After the shootings, she attempted to flee to the airport but was apprehended before boarding a flight. Authorities believe King specifically targeted Freeman and Shinners due to ongoing legal disputes. She had filed lawsuits against both, accusing them of fraud and misconduct related to her whistleblower claims. During the subsequent hearing, King repeatedly interrupted the judge, questioning her eligibility for a public defender. Despite King's requests to speak, the judge ruled that bond would be denied, citing the severity of the charges, including murder.
Now, Mr. Cho informed me that I did not qualify. I am not sure what he based his assertion on, right? Now, I do not have...
Ms. King, ma'am?
Yes.
I appreciate your position, ma'am, and I'm glad you're thinking about these issues. But as far as their impact on today's proceedings, they're not going to have an. I am precluded from setting bond for you per court's delegation order. And so I'm going to deny bond. Your case will be heard at a later date before a different judge, either with Mr. Cho or a different attorney. You will have a great deal to say about whether or not it's Mr. Cho or a different attorney. But as far as my jurisdiction and authority to consider bond today, in light of the top count of murder, I am precluded by our delegation order from setting bond for you. So you are going to be no bonded for today. I encourage you to hire another attorney or get Mr. Cho and Ms. Markowitz will be following back up with you. And that will be the order today. Ms. King May, you are free to go.
May I ask,
Ms. King May, you are free to go, ma'am.
Come on, Ms. King May, come on.
On August 24, 2022, a grand jury indicted King on multiple charges, including 2 counts of murder and 5 counts of aggravated assault. The indictment followed her shooting spree, where she allegedly targeted individuals involved in lawsuits she had filed. The legal proceedings continue as King's competency to stand trial has been called into question. In June 2024, a psychological evaluation determined that King was not mentally fit to understand the charges or assist in her defense, leading to her commitment to a mental health facility for further treatment. On the evening of October 9, 2019, Sabra Toiver, a 31-year-old woman from Lakewood, Ohio, was driving on Interstate 71 southbound near Snow Road in Brook Park. She entered a marked construction zone where workers were doing pavement striping. In a tragic turn, Toiver's vehicle struck 2 construction workers, 61-year-old Rafael Solis, who was killed instantly, and 25-year-old Brandon Hruska, who was seriously injured, requiring surgery and hospitalization. Instead of stopping to offer help, Toiver fled the scene. However, one of the construction workers who had witnessed the incident followed her and eventually spotted her at a nearby restaurant on Bagley Road, where the police apprehended her. A breathalyzer test revealed that her blood alcohol content was more than twice the legal limit, and traces of marijuana were also found in her system.
On the first felony charge, the complaint reads as follows. Complainant being duly sworn states that, is it Sabra Toiver? Is that how you say it? Sabra Toiver at Brook Park, Cuyahoga County on or about Wednesday, October 9, 2019. No person while operating a motor vehicle shall cause the death of another as the proximate result of committing a violation of Division A of 451119, the revised code, or of a substantially equivalent municipal ordinance. To wit, Sabra Toiver did cause the death of Raphael Solis while operating a motor vehicle while under the influence of alcohol, a drug of abuse, or a combination. So that's aggravated vehicular homicide. It is a violation of Section 290306A1A of the Ohio Revised Code. It is a second-degree felony. As such, if you plead guilty or found guilty of that charge, the maximum punishment would be 8 years of jail and a $15,000 fine. And then the second felony charge, the complaint reads as follows. Complainant be duly sworn, so it says Sabra Toiver at Brook Park, Cuyahoga County on or about Wednesday, October 9, 2019. No person while operating a motor vehicle shall cause serious physical harm to another person as the proximate result of committing a violation of Division A of Section 451119 of the Ohio Revised Code, or of a substantially equivalent municipal ordinance. To wit, Sabra Toiver did cause serious physical harm to Brandon Ruska while operating a motor vehicle while under the influence of alcohol, a drug of abuse, or combination. So that's a violation of 290308A1A, aggravated vehicular assault. And that's a third-degree felony, and as such, if you plead guilty or found guilty, the maximum punishment would be 5 years of jail and a $10,000 fine.
Toiver was arrested and charged with aggravated vehicular homicide, aggravated vehicular assault, driving under the influence, and fleeing the scene of an accident.
Your Honor, my client's 31 years old. She currently resides in Lakewood with her fiance and her 10-year-old daughter at the address that she had on the court file. She's been there for over a year. She's currently employed with the Chipotle restaurant in Lakewood. She's been at that restaurant for over a year as well. No prior criminal record in terms of felony. She had one prior OVI back in 2014. We'd ask the court for a reasonable bond in this matter.
Thanks. Officers, do you have anything as to bond?
We defer to the court, Your Honor.
Okay. Well. In this matter, there's a death and a serious physical injury, and the consequences are extreme to Ms. Toiver. And the circumstances, taking into account personal circumstances of Ms. Toiver, the nature and extent of the charges here. Bond is going to be $1 million, cash or surety. Anything else today, Mr. Kudinski?
No, thank you so much, Your Honor.
Nice job.
The consequences of Toiver's actions were significant, and the charges she faced carried severe penalties. Considering the potential flight risk, the judge set Toiver's bond at $1 million, cash or surety, to ensure her appearance in court and to reflect the serious nature of the offenses. She initially pleaded not guilty to the charges, but later changed her plea to guilty. In July 2021, Toiver was sentenced to an indefinite prison term of 10 to 12 years. In accordance with Ohio's Reagan-Tokes law, the law permits the sentence to be extended depending on the behavior and other factors related to the offender's rehabilitation. Stanley Ford, a 62-year-old man from Akron, Ohio, was convicted for a series of deadly arson attacks between 2016 and 2017, which resulted in the tragic deaths of 9 people, including only 2 adults. Ford's motive was rooted in personal grievances against his neighbors, whom he believed were engaged in behaviors such as gambling, alcoholism, and homosexuality. actions he disapproved of. Instead of addressing these issues through lawful means or community engagement, Ford chose to retaliate by setting fires to their homes, all in predominantly black neighborhoods. Legal proceedings were delayed over 4.5 years, primarily due to the challenges posed by the COVID-19 pandemic. Despite these setbacks, the court took the necessary precautions to ensure a safe trial. After a lengthy and contentious legal battle, Ford was convicted in September 2021 on 26 charges, including 22 counts of aggravated murder, aggravated arson, and attempted aggravated murder. The trial lasted several weeks and had a significant impact on the Akron community. While Ford was acquitted on 3 counts related to a car fire and 1 charge involving a dog, the weight of the charges and the devastating loss of life shook the local population. Throughout the entire process, Ford maintained his innocence and showed no remorse for the destruction and loss he caused. On October 26, 2021, during sentencing, Judge Christine Croce highlighted the severity of Ford's actions, describing them as senseless, tragic, and completely unnecessary.
For the insight into that family, because I don't think any of us knew that. We didn't know about the children. We knew about the children, we knew about their ages, but we didn't know about what a close-knit family. And we heard from Mr. Lindell Lewis's sister, so we have some insight into him and to Gloria. But we didn't have insight into the Huggins' family and the Boggs' family. And so we want to thank you for that. And you know, many people will see this type of emotion for me as a sign of weakness. I consider it compassion for all of you, because these are senseless, they're tragic, and completely unnecessary. The compassion that the Huggins' family has shown you, that you refuse to show your neighbors, is if you show them half of that, they would still be alive today. You may have gotten to know them. You may have found that you liked them. Instead of accusing them of being homosexuals, of being alcoholics, of being gamblers. But you chose to take it into your own hands. You chose to seek revenge and not live by the Bible.
I disagree with that, Your Honor.
You had an opportunity to talk, you're done. It's my turn. I have sat on my hands for 4.5 years and listened to you rant and rave about how you've been railroaded, how the evidence has been tampered with, how they're setting you up, how I was giving signals to them, how I'm on their side, when I bent over backwards to assure that you had a safe, effective, and fair trial. A jury of your peers that you were in the process and proceeded to select have found you guilty of killing 9 people and attempting to kill 1 other person and starting 2 fires. And to watch, not a word, Mr. Ford, and to watch that video and to watch you enter that house, knowing that the first one you set killed 2 people, and knowing that you were setting the second one, that there were 7 people in that house, and you still chose to do that in the cover of darkness, knowing that those houses go up in a blaze, knowing that there are people sleeping in those houses. If you wanted them out of the neighborhood, you could have proceeded a lot differently. To watch that video of Lindell Lewis and Gloria Hart's house go up in flames, and to know that those people were inside while that video was going, I can only imagine the fear in all of them. And for those babies being huddled underneath their parents, while Jared Boggs is trying to get from the 3rd floor outside to get help. And the lives of the firefighters that you put at risk by having to go in that house to put those fires out and to potentially walk through a house that could have collapsed at any moment to retrieve those victims. There are no words to explain it. It is the most atrocious version of these types of offenses that could possibly happen. And while you have maintained your innocence throughout this trial, you have shown not a shred of sympathy or remorse during this 4.5 years. So I thank the Huggins and the Boggs family for your dedication, your continued support and commitment to this process. Our system is not perfect, but it's the only one we have. And there were times when this was tumultuous, there were times when it was confrontational, but we all worked through it, and I believe got to a point where we are today.
The judge contrasted Ford's lack of remorse with the immense compassion shown by the victims' families, who, despite their grief, displayed understanding and forgiveness.
Every day you serve for the rest of your life, you will know that you have been sentenced for the death of each one of these victims and the attempted death and attempted murder of Thomas Hughley. I find that one or more of these offenses was committed while at least two of those offenses, were committed as part of one or more courses of conduct, and the harm caused by two or more of those offenses was so great or unusual that no single prison term for any offense committed as part of the course of conduct adequately reflects the seriousness of the conduct. And I also find that your criminal history, while you had a significant term of nonviolent living, I also find that your criminal history demonstrates that consecutive sentences are necessary to protect the public from future crime. Therefore, as to the death of Angela Boggs in count 1, I'm imposing a life in prison without the possibility of parole, consecutive to count 9, the aggravated murder of Dennis Huggins, and I'm imposing life in prison without the possibility of parole. Consecutive to count 10, the aggravated murder of Jared Boggs, you will serve life in prison without the possibility of parole. Consecutive to the aggravated murder of Deja Huggins in count 15, where you will serve a sentence of life in prison without the possibility of parole. Consecutive to count 16, the aggravated murder of Kyle Huggins, and you will serve a sentence of life imprisonment without the possibility of parole. Consecutive to Olivia Huggins in count 17, where you will serve a sentence of life imprisonment without the possibility of parole. Consecutive to count 18, the aggravated murder of Cameron Huggins, where you will serve a sentence of life imprisonment without the possibility of parole. Consecutive to count 21, the aggravated murder of Dylann Roof, where you will serve a sentence of life imprisonment without the possibility of parole. And count 24, the aggravated murder of Gloria Hart, where you will serve a sentence of life without the possibility of parole. 9 consecutive life counts consecutive to the attempted aggravated murder of Thomas Hughley and the RBO specification. 9 life sentences consecutive to each other without the possibility of parole, consecutive to 21 years. Lastly, I have ordered restitution. I will not order a fine. I will order that on the following dates you will be held in solitary confinement.
Ford's defense team requested that the court spare him the death penalty, and the judge sentenced him to 9 consecutive life sentences without the possibility of parole. He also received an additional 21 years for a separate arson attack that did not result in any fatalities. It was the early hours of March 25, 1993, when 2 women, Cheryl Jenkins and Wendy Sweeney, were delivering newspapers along a quiet road in Thompson Township, Gauga County, Ohio. As they drove their usual route, something unusual caught their attention. A black garbage bag left near the edge of the road. Curious and slightly concerned, they decided to stop and take a closer look. Inside the bag, to their shock, was the body of a boy, his umbilical cord still attached. It appeared he had been placed there recently, and nature had begun to take its course, exposing the scene to those who would find him. The discovery deeply affected the small, tight-knit community. With no information about his identity or where he had come from, the town organized a proper funeral, burying him in Thompson Township Cemetery with a headstone that carried a touching message of remembrance. The case was heartbreaking and mysterious, and despite the efforts of law enforcement, there were no solid leads. Forensics at the time was limited, and the mother's identity remained unknown. Over time, the case went cold. Yet for those who worked it, like investigator Thomas Dewey, the boy was never forgotten. Dewey would sometimes visit the boy's grave, silently promising not to give up on the search for the truth. In 2018, the case was reopened with the help of advanced DNA technology and a technique called genetic genealogy. Preserved tissue samples from the boy were sent to a specialized lab in Virginia. Through DNA databases addresses and careful mapping of distant family connections, investigators slowly began to trace his family tree. It took months of detailed work involving over 1,000 relatives, but eventually the search pointed to a woman named Gail Eastwood Richie living in Euclid, Ohio. In 2019, investigators approached Gail with questions. She admitted that she had given birth to the boy years earlier while working as a live-in nanny in Shaker Heights. According to her, she hadn't realized she was pregnant until shortly before giving birth, and she believed the boy hadn't survived. Overwhelmed and unsure of what to do, she placed him in a bag and kept him in the trunk of her car for a few days. Later, during a church retreat, she drove out to a rural area and left the bag in the woods. To the investigators' surprise, Gail also mentioned that something similar had happened before a few years earlier. She had given birth before and committed the same crime, but in a separate location in Cuyahoga County. A search was conducted in that area, but no remains were ever found. Gail was arrested on June 6, 2019.
Mr. Bradley, can you and your client approach the bench, please?
Certainly.
I'm going to ask that Ms. Richie stand on the side closer to the court reporter. So that's good. Thank you. All right. Ms. Richie, have you received a copy of the indictment?
Yes.
And have you read the indictment?
Yes.
Do you understand the indictment?
I do.
Mr. Bradley, on behalf of your client, do you waive a formal reading of the indictment?
We do, Your Honor.
All right. So I'm not going to read that to you word for word, but I do want to go over with you the maximum possible penalties for each of the counts, okay?
Yes.
All right. Count 1 is aggravated murder. If convicted, that could carry with it a life sentence with the possibility of parole after 20 years and a maximum possible fine of $2,500. Count 2 is murder. If convicted, that could carry with it also a life sentence with a possibility of parole after 15 years and a maximum fine of $15,000. Do you understand those penalties?
Yes.
Okay. You have the right to counsel. You have the right for a reasonable continuance to obtain counsel. If you cannot afford counsel, counsel will be provided for you at the state's expense. You have private counsel here with you today. If something happens in your financial circumstances and you're no longer able to afford private counsel, counsel will be appointed for you at state's expense. You have the right to remain silent. You have the right to a jury trial, and you have the right to reasonable bail. Do you understand those rights?
I do.
All right. Now I have. You have something, Mr. Place?
Yes, Your Honor. With the aggravated murder, it's a potential $25,000 fine is the maximum.
Oh, did I misspeak?
Yes, you did.
I
Sorry.
apologize. You understand that correction that Mr. Fleisch just made?
Yes.
Okay. All right, I have the designation of trial attorney here that is filled out by Mr. Bradley. So we have that. And I have here, Ms. Richie, a waiver and request form. This indicates that you understand you cannot be called upon to enter a plea at your initial appearance, but that you're waiving a separate arraignment and requesting to enter a plea of not guilty at this time. Is that correct? Yes?
Yes.
Okay. And I'm going to show you the form. Is that your signature toward the bottom?
Yes.
All right. Okay, so I'm going to accept your plea of not guilty, and we're going to assign a judge to your case, okay?
Judge David M. Andre.
Okay, your case has been assigned to Judge Andre, which means your future hearings will be upstairs on the second floor in front of Judge Andre.
Eastwood Richie was formally charged with aggravated murder and murder.
All right, and Mr. Fleiss, does the state have a recommendation regarding bond?
Yes, Your Honor, we do. The state does acknowledge this is a difficult matter for bond setting, given the circumstances of the case. But obviously the purpose of bond, primary purpose, is to secure appearance. The state does acknowledge the defendant has a lack of criminal record other than this incident and another incident I'll mention. And the state does acknowledge strong ties to the community by the defendant. However, the defendant is facing a mandatory life sentence for both of these charges. The defendant did confess to this crime, and the defendant also confessed to committing a similar crime that is currently being investigated in Cuyahoga County. So given those circumstances, the state would recommend a $250,000 cash surety or 10% bond, and if the defendant does post bond, that she be ordered to have GPS location tracking at her cost, at the defendant's cost, pretrial release with weekly contact with the pretrial release officer, that she not be permitted to leave Ohio, and that she surrender a passport if she does indeed have a passport. Thank you.
Thank you. Mr. Bradley?
Judge, as Mr. Fleiss pointed out to you, the primary purpose of bond is to ensure her appearance at all subsequent stages of these proceedings. And as he points out, there's unusual circumstances to this case. The offense conduct relates back some 26 years. She has long-standing ties to the community. She's married, her husband's in the back of the courtroom, fully supports her in this case. She has children, she owns a home, she has extended family in the area. She does not have a passport. They certainly have means, but somewhat limited means when you consider they need to pay for a defense here. And I would suggest that a $250,000 bond would do nothing more than create a financial hardship to Ms. Richie. So we would ask you to consider something along the lines of a $50,000 bond. When you take into consideration the conditions of bond that the prosecution has proposed, GPS monitoring, regular contact with the probation department, etc., together with, for example, a $50,000 surety or 10% bond, that would more than adequately ensure her appearance at all subsequent stages. I would also note that she was arrested having left my office to consult about possible representation before she, of course, knew that there was a warrant for her arrest. The point being is that, you know, she was preparing to retain counsel and deal with these charges. And that's certainly a clear indication that it's not her intentions to go anywhere. She's going to stay where she's been her entire life and deal with these charges. So we would ask you to consider something more along the lines of a $50,000 10% bond. Thank you.
Thank you. All right, I'm going to set bond at $250,000, 10%. And Ms. Richie, I'm going to order our standard bond conditions. You're ordered not to possess or consume alcohol or drugs unless prescribed by an MD, a DO, or dentist. You're ordered not to enter bars or places where alcohol is served as a primary source of income. You're ordered to submit to random alcohol or drug testing by means of breath, blood, or urine sample. You are ordered to report to pretrial release immediately after this hearing and one time per week, either in person or by phone as a pretrial release officer directs. You're ordered to obey the laws of the state of Ohio and not leave the state of Ohio without permission from the court or from your pretrial release officer. I am going to order GPS monitoring at your expense. The cost for that is $9 a day with $100 for the installation.
During her arraignment, she pleaded not guilty, and the court set her bond at $250,000 with a 10% cash or surety option. The judge imposed standard bond conditions, including GPS monitoring and restrictions on travel. The trial finally began in April 2022. Her defense team argued that she had panicked, thinking the boy was already gone and not knowing what to do. The prosecution believed otherwise, pointing to her actions and the fact that she didn't seek help or tell anyone.
Your wrongful efforts to conceal what happened in February 1993 did buy you 29 years of normal life where you got the chance to get married, raise children, and do some good works. But ultimately you gained that time on the back of a helpless infant whose body you concealed in the woods. Ironically, Jaga's child did more for you than you ever did for him, probably. Your freedom is over. It is finally time to atone for these awful, unnecessary deeds committed 3 decades ago. So I sentence you to life in prison with the possibility of parole in 15 years.
The jury ultimately found her guilty of murder, though not aggravated murder. In May 2022, she was sentenced to life in prison with the possibility of parole after 15 years. Judge David Andre described her actions as inhumane and difficult to comprehend. In late 2017, 38-year-old Latasha Wisniewski of Strongsville, Ohio, entered the life of 89-year-old Charles Bauer, a Korean War veteran and recent widower living in Parma Heights. Grieving the loss of his wife of 65 years, Bauer was in declining health and emotionally vulnerable. Wisniewski presented herself as a compassionate helper and soon moved into his home under the pretense of caregiving. Once inside, Wisniewski quickly gained control over Bauer's finances. Over the course of several months, she drained approximately $150,000 from his bank accounts. The stolen funds were used for her personal indulgences, including cosmetic surgeries. Bauer's daughters began noticing changes. Their father was increasingly isolated, and financial red flags were piling up. When they voiced their concerns to Bauer, he insisted that Wisniewski was helping him. However, their suspicions grew stronger, and in February 2018, they reported the matter to the Parma Heights Police Department. The investigation revealed a deeper scheme. Wisniewski had not acted alone. Her aunt, Lisa Dotson, a home health aide with a questionable history, was also involved. Dotson confessed to helping Wisniewski cash checks from Bauer's account and admitted to receiving a 50% cut. In exchange for an 18-month sentence, Dotson testified against her niece in court. In September 2019, Wisniewski was found guilty of theft and money laundering. Sadly, Bauer died before he could see full justice served, but his daughters were present in court, expressing both sadness and relief that someone was finally held accountable.
Charlotte Young, and I'm Charles Bauer's eldest daughter.
Can you spell your first name for me?
Charlotte.
Okay, and your last name is spelled Young?
Yes, it is.
All right, Mrs. Young. Why don't you tell me what you would like me to know?
Okay. Our parents were members of the Greatest Generation, which is a term coined by NBC News anchor Tom Brokaw. Some of the characteristics include personal responsibility, humility, a strong work ethic, and prudent saving. They instilled these same characteristics in their children, including doing the right thing and be grateful for what we had. A penny saved is a penny earned. If we wanted something, we had to work for it. Nothing was handed to us. We've all had our differences with our dad at times. Who doesn't? But we always managed to work things out. We understood that he was still grieving the loss of our mother.
Ms. Young, I'm going to just ask you to slow down a little bit when we read.
Okay.
I'm going to go a little bit faster.
Okay.
Thank you.
We understood that he was still grieving the loss of our mother, his wife of 65 years, and we saw how her death affected him and us as we slowly watched her decline to the effects of Alzheimer's disease, which took her life. We had told our dad that we had concerns about his relationship with the defendant and that he should not share his financial status with her or let her near his money. We could see the defendant for what she was. After the initial police report in February of 2018, the defendant wormed her way back, telling him it was a big mistake and continued to take advantage of his kindness to her. He trusted her to pay the bills, just like our mom did. He claimed the defendant was working and going to school. There were also several times after that when family members did stop by and were occasionally allowed in the house. Well, there were bunk beds set up in one room and another room was furnished with bedroom furniture he had purchased. The drawers were always empty and there were no personal effects anywhere. No toothbrushes, hairbrushes, makeup on the dresser or in the bathroom. No special soaps, lotions, creams, hair dryers. Dad always said the defendant was going to move in, but the furniture was just for show. The defendant had no plans on living with our dad. The fact that she never lived there can also be verified with his various neighbors. Once our dad threw the defendant out, he closed the bank accounts and even tried to have the deed to the house changed back to no avail. His actions at that time showed that he finally saw the defendant for what she was, and if his deposition would have been taken in a timely manner, we would not be here today defending him. Once our dad got over the shock of what happened, he was depressed, embarrassed, and humiliated. Ironically, we recently found out that on September 4th, 2018, Just a few days after being confronted by our dad, the defendant and Dan Schultz applied for a marriage license. The defendant took more than our dad's money and physical assets. She took our dad, whose health was failing, from us during that time. Your Honor, the defendant's past history with the legal system speaks for itself. She has had several prior probation violations and community sanction violations. She was on probation for the same thing when she began funneling our dad's money. She has no regard for the law. When the defendant, a repeat offender, was found guilty of the various charges, we asked that she be given the maximum sentence allowed for each charge and that they be served consecutively with no chance for parole, so that no other elderly person or their family member becomes one of her victims and has to go through what we have been through, both emotionally and financially.
Bauer's daughters described how Wisniewski had manipulated their father, isolated him from his family, and exploited his trust during his most vulnerable years.
Your Honor, it is with great sadness that we are here today.
I'm going to tell you the same thing I told your sister. Just go a lot slower.
Okay.
I can already tell you're going a little fast.
I'm nervous.
I understand. Take a deep breath and take your time.
Okay. Your Honor, it is with great sadness we are here today without our father. Latasha, you've said on many occasions you only wanted a chance with our family so we could see who you really were. Yet even with such a bold statement and under the circumstances, your only effort was in fact quite the opposite, and your actions only proved our suspicions accurate. We watched you work hard at driving a wedge between my dad and his family. You moved in quickly to befriend him and to gain control of every aspect of his life. You alienated him from longtime friends who've known him for longer than you've been alive. You made him believe his family, who loved him very much, was out to get him, and that we only wanted his money, when in fact everything you tried to make him believe of us was actually indicative of what you were doing and what you had set out to do from the very beginning. If you remember your first meeting with my daughter back in September of 2017, when you were invited to my daughter's home for the weekly family dinner, opportunity presented itself for the two of you to get to know one another. There was a particular conversation that took place. If you recall, you sat in her home, in her living room, and made the comment how, quote, you knew what this looked like. When Jen asked you to elaborate, you then stated how, quote, you know a much older man with a much younger woman is usually viewed as a gold digger and only wanting money. Since you had brought up what she was thinking all along, she then asked point blank what you meant and what your intentions were with him, to which you then told her, I only wanted a friendship with him, and how I wouldn't take $1 from him when he offered or not. When in fact you lied straight to her face, because shortly thereafter I asked my daughter if my dad gave her money, to which at that time he did not. After further investigation by our family, this woman only knew my father only a matter of a week at this point. She was merely a stranger and a predator. The defendant acted quickly when it came to interjecting herself into every facet of my dad's life. She moved into his life like a whirlwind and began deceiving and manipulating him from the very first day. The defendant took every advantage of my father and of his failing health, his kindnesses, and of his vulnerabilities. This woman preyed on him like an animal, just as she preyed on the others she's been convicted of doing the same thing to. Latasha, your actions and lack of accountability only show your true character, sheer selfishness, and the desire to only fulfill your own selfless needs. You knew from the very beginning what it was you had set out to do. You viewed him as someone to prey upon because to you he was an easy target. What we have all seen of this woman do is nothing short of repulsive. The defendant sits here smug, showing zero remorse. The only tears she has shed are for herself and the time in which she is facing in prison for the convictions against her.
Judge Shannon Gallagher sentenced Wisniewski to 3 years in prison on each charge, to be served concurrently. She was also ordered to pay full restitution to Bauer's estate and placed under 3 years of post-release supervision. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.